Welcome to this explainer. Today, we're unpacking one of the absolutely most debated, controversial, and frankly fascinating topics in all of Canadian criminal law. It's a story of constitutional rights clashing head-on with public safety. And honestly, it plays out like a century-long tennis match between the highest court in the land and the nation's lawmakers. So let's jump right into this.
It's kind of a jarring question, right? Can being too drunk actually excuse a violent crime? On the surface, the answer seems like an incredibly obvious no way. But legally and morally, it opens up this massive dilemma. In this explainer, we're going to unpack exactly how the Canadian justice system attempts to balance the absolutely crucial need for public safety with the fundamental constitutional rights of an accused person. And you might be wondering, why does this matter so much? Well, because we're constantly weighing the very real danger of a violently intoxicated attacker against the frankly terrifying prospect of locking a citizen up for a completely involuntary action.
All right, Section 1, the basics of criminal intent.
Okay, so the first piece of the puzzle we need to understand is mens rea. It literally translates to guilty mind. In our justice system, it's generally not enough that you just did something bad. The prosecution actually has to prove you intended to do it. This is the specific mental element required for a crime. You have to have some level of awareness or intent behind your actions.
And partnered up with that guilty mind is the actus reus, or the guilty act. This means the physical action itself must be a voluntary commission of a prohibited act. The absolutely crucial word here is voluntary. Think of it this way. If someone violently shoves you into another person, you didn't assault them, right? Because you weren't consciously in control of your own body. Your action simply wasn't willed.
So the big sticking point is how the law divides these intents. On one hand, we have specific intent crimes. We're talking murder or robbery, things that require complex thought or ulterior motives. On the other hand, we have general intent crimes, like manslaughter or assault, which require only a minimal amount of intent just to perform the immediate physical act. Now, traditionally, getting really drunk could only be used as a defense for specific intent crimes. The logic was that extreme intoxication might actually prevent you from forming that complex thought process.
And Canadian courts drew this specific line largely out of policy concerns. Because think about it, if a person is so drunk they get acquitted of a specific intent crime, like murder, they don't just get to walk out the door scot-free. They are typically convicted of the lesser included general intent offense, like manslaughter. It essentially acts as a legal safety net for society.
Let's look at how this all builds over time. This is where the legal ping-pong match really gets going. The genesis of the modern intoxication defense actually starts way back in 1920 with a case called Beard. But the real fireworks, those happen in the modern era. We see a massive shockwave from the Supreme Court in 1994, an immediate, forceful counterattack by Parliament in 1995, and then a final reversal by the court in 2022. Let's look a little closer at that 1994 shockwave.
Section 2. The extreme intoxication defense. So in 1994, a case called R v. Daviault came before the Supreme Court. The accused was a chronic alcoholic who consumed a truly staggering amount of alcohol and then committed a sexual assault. Now remember, sexual assault is a general intent crime. Under the old rules we just talked about, intoxication shouldn't have been a defense for him at all. But the Supreme Court dropped a landmark decision here. They ruled that an extreme state of intoxication, we're talking a state so severe it's basically akin to automatism or temporary insanity, could actually be a defense to general intent offenses. They argued that in such a rare, extreme state, the accused is acting completely involuntarily. They essentially lack both the mens rea and the voluntary actus reus that we discussed earlier. Justice Corey actually noted in the Daviault decision that automatically substituting the act of drinking for the intent to commit a violent assault violates the Canadian Charter of Rights and Freedoms. The idea is that convicting someone who is acting completely involuntarily, essentially like a sleepwalker, deprives them of fundamental justice, even if that state was totally self-induced by alcohol.
Moving on to Section 3, Parliament restricts the defense.
Well, the public reaction was intense, and within a single year of that Daviault decision, Parliament fought back. They quickly passed legislation, adding Section 33.1 to the Criminal Code. Their goal was incredibly straightforward. They wanted to protect victims, particularly women and children, from intoxicated violence and ensure offenders were actually held accountable.
What Section 33.1 did was legally block the extreme intoxication defense for general intent crimes that involve violence or threats to bodily integrity. It basically drew a line in the sand and said, look, If you get so drunk that you lose control and hurt someone, your decision to get that drunk in the first place is a marked departure from the standard of reasonable care recognized in Canadian society.
To put this into perspective, before Daviault, an older law called the Leary rule basically said that simply becoming intoxicated supplied the fault for any general intent offense. Section 33.1 codified a slightly narrower version of that. It legally substituted the fault of voluntarily getting intoxicated for the actual fault of committing the violent act. So if you drank and then you hit someone, the law essentially treated you exactly as if you intended to hit them.
Section 4. The Supreme Court strikes back.
Now, let's fast forward 27 years to May 2022 in the case of R. v. Brown. In this situation, an individual consumed magic mushrooms on top of alcohol. He entered a completely unexpected psychotic state, broke into a home, and assaulted a stranger. He had zero control and zero intent, but under Parliament Section 33.1, he was legally barred from using his extreme intoxication as a defense.
Well, the case made it all the way to the Supreme Court, and the result this time was definitive. The court unanimously struck down Section 33.1. They entered an acquittal for the accused, stating clearly that he did not commit the guilty act voluntarily and was literally incapable of forming even the bare minimum required degree of intent.
The court's reasoning here was deeply rooted in the Charter. They found that Section 33.1 was an unjustified violation of Section 7 and Section 11D, which guarantee fundamental justice and the presumption of innocence. The court totally agreed that protecting victims is vital, for sure, but they argued you simply cannot constitutionally convict a morally innocent person who acts completely involuntarily just because they chose to consume an intoxicant without any actual proof of criminal negligence.
And finally, Section 5, a new standard of negligence.
Parliament, however, didn't just sit around and wait. In June 2022, literally just weeks after the Brown decision, they passed Bill C-28. This was a rapid, highly targeted response specifically designed to fix the constitutional flaws of the old law while still making sure the public was protected from intoxicated violence.
And Bill C-28 does something really clever. It actually preserves the extreme intoxication defense, meaning, yes, if you are in a legitimate state of automatism, you can raise it. However, it introduces a very strict criminal negligence test. It essentially gives prosecutors a brand new, specific hurdle they can use to defeat the defense and hold the accused accountable.
So in practice, to defeat the defense today, the Crown has to prove the accused was criminally negligent when they consumed the intoxicants. They have to prove that a reasonable person would have objectively foreseen two main things. First, the risk that taking the substance could cause extreme intoxication, and second, the risk that it could lead to them physically harming someone else. So it's no longer just this automatic substitution, it's a very real test of objective foreseeability.
Which really leaves us with this final, profound question to think about. Through a whole century of legal ping-pong, from Beard all the way to Daviault, through Section 33.1 to Brown, and now this new Bill C-28, Canadian law has desperately tried to thread the needle. We absolutely want to protect innocent victims from violence, but a free society also demands we only punish those who act with a guilty mind and a voluntary body. Has Bill C-28 finally achieved that precarious balance? Well, only time and future court cases will tell. Thanks so much for joining me for this explainer. I really hope it brought some clarity to an incredibly complex topic.